Hello, today we're going to be doing our labor law presentation and analyzing the employment relationships in case 1 and case 2. Before we begin analyzing the cases, we must mention the framework that we're going to use to analyze them. The Department of Labor is a department of U.S. federal government responsible for things such as occupational safety, wage and hour standards, unemployment insurance benefits, and other labor-related aspects. The Department of Labor created the economic realities test, which is a multi-factor balancing test used to analyze whether a worker is an employee or a contractor. It has been used, for example, in acts such as the Fair Labor Standard Act of 1938, which set the right to minimum wage, for example, among other things. The key question it answers is whether the worker is economically dependent on the company or is in business for themselves. If the worker is economically dependent, then the worker is an employee, and if the worker is economically independent, the worker is an independent contractor. The economic realities test has 6 factors, and broadly speaking, they relate to how integral the worker is, the worker's opportunity for profit and loss, the worker's investment with relation to the employer's investment, how much skill is required to do the job and the worker's initiative, the permanency of the worker and the worker's relationship with the company, and how much control the worker has. So for the first case, it relates to Yasmin Iborra, who is a worker who had been working for 18 months intermittently as a lap dancer at both appellants' 2 strip clubs, Lonnie Fool and Strivers. And on September 15, 2016, she was told that she was not allowed to work anymore because she was believed to be involved with drugs on the premises. So the question is here whether this is an employment relation or not.
When deciding what kind of relationship Yasmina and the club have, the first factor to look at is whether or not the work is an integral part of the employer's business. From the facts of the case, we can infer that the club is actually a strip club, and so as a dancer, she provides the main service and the main function of the club. The second factor is whether the worker's exercise of managerial skill affects his or her opportunity for profit or loss. If someone is carrying out their work and doing their own advertising and marketing, deciding on which jobs to perform and how to perform them, they are exercising managerial skills. We can say that this is not in fact the case for Yasmina, because the club offers space and brings customers. Based on that, she performs and gets remuneration. It is for that reason that she is not exercising managerial skills. The next factor is how the worker's relative investment compares to the employer's investment. In this way, we know that Yasmina's investment is a lot less than that of the club's, although she does pay a fee in order to perform and does buy her own outfits. The company provides the forum at which she dances. They provide the prestige and the reputation and bring in the customers that directly pay her. And so we know that the investment of the rent and other workers that are needed to run the club are a lot higher than the investment that she makes. Therefore, the fourth factor looks at whether the work performed requires special skill and initiative. If the worker relies on your business skills and initiative to create the worker is likely to be an employee. This factor goes in hand with factor 2. Yasmina does not take initiative. She directly depends on the club to provide her services. She does not book directly the customers, and she does not decide when to perform as she has a shift. She carries out the service in the name of the club. The fifth factor is whether the relationship between the worker and the employer is permanent and indefinite. And we know that the working pattern of the dancers is quite strict because their shift runs from 9 to 4:30 a.m. and they have profitable nights that are Tuesday, Wednesday, and Thursday, but they are also obliged to work both Saturday and Monday every second weekend on top of the usual set days. However, we also know that Yasmina herself only works on average 2 or fewer days in the 42 or 80 weeks that she has been working at the club. Although this might indicate that Yasmina has worked less than other dancers, it is still indicative of the long-term relationship that she has developed with the club, as we know she has only been working for the club. The next and last factor is the nature and degree of the employer's control. We know that the more control you exercise over the worker, the more likely it is that this relationship is that of an employer and an employee. From this, we can conclude that Yasmina does have a working relationship or an employee relationship with the club because they have so much control over her and the other dancers. They have strict working patterns, they are expected to shop from a specific supplier, and they are all under the impression that they should not dance for another company. Management also requires the dancers to look elegant. They are entitled to determine when they perform and which stages they are allowed to use, and this directly affects the money that they make. In conclusion, when looking at the factors provided by the Department of Labor, we know that the bottom line is that the more intertwined the relationship between the worker and the employee are, the more likely it is that they have an employee relationship. Based on the facts, it can be concluded that Yasmina does in fact have an employee relationship with the club, even though they claim that the dancers are independent contractors.
The second case relates to the legal status of 20 Carvalho workers for the company Clean Car, who are seeking a declaration that they are employees and therefore are entitled to holiday pay, whilst Clean Car, the company, states that the Valo workers are actually self-employed contractors and are not entitled to statutory rights.
The first thing we need to ask is the work an integral part of the employer's business? We know that the workers are providing the work of valet, which operates in the Clean Car valet operations. Clean Car has many different depots, but all of these workers are working in the Bastia depot, which is all one location, and they're providing the service of valet. Without these workers, Clean Car would not be able to provide their service. The second question is, do the workers' managerial skills affect the workers' opportunity for profit or for loss? And when we look at the situation of the workers, we see that their wages would increase if they were to clean more cars. But the case doesn't make any mention that the workers are working elsewhere, that they're looking for other jobs to increase their income in that way. They're not using their management skills in order to generate more opportunities of work for themselves. So this could mean that they are probably employees. The third question is, how does the worker's relative investment compare to the company's investment? So Clean Car provides the insurance as well as the work uniform for the workers. They also provide them with the equipment at a discounted rate that the workers must purchase at their own expense, or the cost of the equipment can be discounted from the salary of the workers when they are paid. So for this reason, because the workers are providing their own equipment to perform the work, they could probably be contractors. The next question is, does the work performed require special skills and initiative? The workers rely on Clean Car to create work. Like I mentioned earlier, they are not actively seeking out work. The work that they are performing, it comes about because Clean Car has their clients, which is the FCA. So the workers rely on Clean Car to create the work for them. So for this reason, they might be employees. The next question is the relationship permanent or indefinite? So we know from the case that the workers are working from time to time, but the hiring advertisements promote the job as permanent. So because the workers are working repeatedly over a long period of time compared to, it doesn't make mention that they're working for a short period of time, but it says from time to time and it's advertised as a permanent job. For this reason, the workers are probably employees. And finally, if we ask ourselves, what is the nature and the degree of the control of Clean Car over these workers? We know from reading the case that Clean Car controls how the work is done. There are very strict rules about the cleaning process and how it should take place that the workers have to follow. And because of this level of control, the workers are probably employees. So after looking at all of these questions, we see that for 5 of them, it points to the possibility that these workers are employees rather than subcontractors. With these determinations, we can see that Clean Car should have classified the workers as employees. They should have deducted payroll taxes from their wages, and thus, as the workers are advocating for paid holiday among other benefits of employees, they should be granted this.